Welcome to a really special edition of our Guild of Letting and Management Takeaways. This is a special edition because very recently, in fact on Monday the 8th of September, we saw the Renters' Rights Bill go back into Parliament. Now, we've been waiting for this day and this process to lead towards the final stages of the bill becoming law. So why was the 8th of September extremely important? Well, firstly, it's taken almost a year to get to this point. Obviously, the previous government, under the Renters Reform Bill, had gone through the process quite significantly, but hadn't quite managed to get to the point of where the Reform Bill had become law. This government has moved much faster. So we are at the stage which started on Monday, where the amendments that have been proposed by the House of Lords are being debated by MPs. Now, if you have taken the time to listen to the debate, which took place around 5:30 on Monday afternoon, you can find a recording. You will have noticed that some of the amendments that had been proposed, in total around 300 amendments proposed by the House of Lords, were not addressed on Monday. Now, you could think that that's actually quite disappointing. We're not here to cast aspersions on why only a handful of amendments were looked at in great detail. But it is significant that you follow this process. So I'm just going to talk to you a little bit about what's going to happen next. Now that the House of Commons have addressed the amendments, and I'll give you an idea, a very brief overview of what those amendments consist of, we need to think about what's going to happen next. Now, the bill will go back into the House of Lords, and there are three options, very significant options, of what could happen following this process. The first is that the Lords accept all the Commons decisions, i.e. they accept the consideration that's been given to their original amendments, and then the process comes to an end. They may insist on the amendments, so the House of Lords may insist on the amendments and send the bill back to the House of Commons for MPs to debate those amendments further. And the third option is that the House of Lords may propose alternative amendments to those that have been already made. Now, this process of going backwards and forwards is commonly known as ping pong, and it will continue until both the houses can reach an agreement. Okay, so what does that mean? If they reach an agreement, then we are closer to the bill being granted royal assent, which is extremely important. So, do we have any idea of time frames? Many stakeholders who are very interested in this bill are thinking, myself included, that the possibility is that royal assent will be granted before October, primarily before all the parties have their conferences. So that's one school of thought. If that were to happen, what we are then interested in, and this is very, very important in terms of the practical implications of the bill, and that's the implementation date. So when does the Act officially become law, in the sense of when do you, as landlords, letting agents, property professionals, need to start making changes? And that could be possibly the shortest time frame is 3 months after the bill receives royal assent. possibly, hopefully, it will be 6 months after, because then that will give stakeholders time to prepare, and there's a lot to prepare for. I just want to go very briefly through some of the amendments that were discussed. The first relates to Section 8 and the Ground 1A. Now, the Ground 1A relates to the landlord being able to serve notice if they want to sell the property. The first point to bear in mind, and this is not an amendment, but this is stated in the draft bill, is that this restriction applies to new tenancies. And the restriction is that the landlord will not be able to serve notice during the first 12 months of a new tenancy. And we need to emphasize the word new. Further restrictions that have been debated relate to the reletting period after having served Section 8 under Ground 1A. Now, if a landlord serves notice under the new Ground 1A, intending to sell the property, and the tenant vacates and everything's fine, the landlord will be prohibited from reletting that property for a period of 12 months. Okay, and the thinking behind this is to deter landlords who are not genuinely selling. Okay, there's the pretense that they will sell for them only to turn around and rent to someone else. So this is quite a significant restriction. Now, the same applies if a property has been put up for sale and is going through the process of being sold and the sale falls through. Okay, the landlord must still observe this 12-month restriction. And one of the most significant amendments is that the House of Lords have proposed that that 12-month restriction is reduced to 6, which, you know, is understandable on many different levels. Ground 4A and proposed amendments are that the House of Lords have requested that this Ground 4A, which is predominantly for student lets, is expanded and brings into the fray smaller student properties, such as the 1 or 2 bed properties. Now, this has been rejected by the government, and the government have said that widening this ground might cause problems in terms of the security of tenure for certain tenants. So, for example, postgraduate couples, students that are parents who have roots in the area and therefore need to be protected. So the Ground 4A will predominantly be restricted to student HMOs. A new ground was proposed that sits around carers. So this ground has been put forward and would be Ground 8A. And the proposal is for this new ground to be introduced, allowing landlords to reclaim the property if they require accommodation for a carer, and this has been rejected. The government has said that they are sympathetic to the needs of carers, but they feel that this ground would be subject to abuse, especially around the definition of the term carer. Ground 5A, another new ground that relates to the employment of agricultural workers. So the proposal of the House of Lords would be that this ground would be permitted where agricultural landlords need to house workers who are not just employed but are also self-employed agricultural workers. And this amendment has been accepted, although there will be some revised wording around this ground. Now, one of the amendments and elements of the Renters' Rights Bill that has caused a huge amount of discussion relates to rent increases. Now, within the bill, there are elements that are straightforward in relation to increasing and reviewing rent. The first being the fact that it will be mandatory to use a Section 13 notice, given that all tenancies from the point of implementation of the Renters' Rights Act will be periodic. So the Section 13 will be the only mechanism by which rent can be increased within the private rented sector. The second element is that, as opposed to giving the tenant 1 month's notice in line with a rent date, the landlord would be required to give the tenant 2 months' notice in line with the rent date, which is perfectly acceptable. The more notice they have, the better. So that's the second thing. The third relates to rent increases being in line with market rent. And that's extremely important because landlords and property professionals need to be aware of what is going on in the market, both nationally, in England, regionally, and in their specific areas. So making reference to the Office of National Statistics and also the Rightmove guide price is important to have as resources. The other element relates to the fact that the rent increase will only be permitted annually. So for existing tenancies, you would stick to the rent due date, and that would be the trigger point for the rent review annually. And obviously for new tenancies, the start date of the tenancy and the rent due date, if they're one and the same, that would be the trigger date for the rent increase. So rent increases under the new rules will only be permitted annually. Now, the sticking point. The sticking point here is the fact that the tenant will have the right to challenge the rent increase if they feel that the rent increase is too high, is unreasonable, or perhaps there are other reasons such as disrepair, where the tenant feels that the rent increase is in fact not warranted. What can the tenant do? The tenant can actually use this mechanism now and apply to the first tier tribunal and challenge the rent increase. But the process currently, as opposed to the process in the future, will be different. So the significant difference is that if the tenant takes the rent increase and challenges to the first tier tribunal, and the first tier tribunal agree with the rent increase, so that's known as determination, what will not happen, and this is what the House of Lords are concerned about, is that that rent increase will not be backdated. Now, why is that important? The importance around this is the fact that there is a backlog, and this backlog could potentially get longer and more significant as more and more tenants challenge rent increases. So that's the concern. And the concern is if it takes the first tier tribunal 6 months to make a decision and also agree with the rent increase, effectively the landlord would have lost out on a significant sum of money. Now, the proposal from the House of Lords, and again, this has gone back into the House of Lords, is that the landlord has the opportunity to have the rent increase backdated, and therefore the tenant pays that increase from the day that the rent increase was triggered. Okay, so that's really, really important, and there's lots of issues around that, predominantly the fact that there is a genuine backlog within the first tier tribunal. Finally, another element of the Renters' Rights Bill that has caused a lot of discussion. In fact, this has caused huge amounts of discussion since it was first mooted, and that was in 2019 under the Renters' Reform Bill and the white paper that talked about a fairer rental sector. And that's the points that sit around the tenant's right to request a pet. Okay, so the tenant will have the right to request a pet, so that's fine. The tenant would have to give the landlord a significant amount of information so that the landlord can then make an informed decision within 28 days of the request being made. So that's very important. Now, if the landlord refuses the pet, okay, so consent is refused, the landlord then has a further 5 days to explain to the tenant in writing why consent has been refused. So that's that part dealt with. That's not changed. There's no discussion around that element. The discussion sits around whether the tenant will be required to obtain insurance. And this insurance is to protect against damage caused by the pet. So this is not pet insurance if the pet requires medical attention. This is insurance against damages that have been caused by the pet during tenancy. So it was very clear that things seemed to be going quite well with this, but during the third reading, it was made clear within the House of Lords that pet insurance will not now feature as part of the Renters' Rights Act. So that begged the question, if the tenants won't be required to obtain insurance against damage caused by a pet, should the tenants be paying a higher deposit? And the House of Lords put forward a proposal that if a tenant is given consent for a pet, they should pay the equivalent of 3 weeks' rent as a deposit. Okay, now this has also been rejected. And Matthew Pennycook made it very, very clear that he believes the cap of 5 or 6 weeks security deposit is more than enough to cover any damage caused by a pet. He also added that if the damage is significant and the deposit doesn't cover the damage, the landlord can pursue the tenant through the courts, okay, which, you know, the school of thought is that that's not very helpful. So that's where we are, but we'll see if there's any further movement on that one. Finally, in terms of the burden of proof in relation to civil penalties, now, the majority of legislation within housing law, and there are some significant exceptions to this, usually sit under civil penalties as opposed to criminal. And what the House of Lords requested here in terms of their proposal, that the local authorities would be required to provide a burden of proof, which is of criminal standard as opposed to civil. And that's in relation to certain breaches within the Renters' Rights Act, as it will be known, and that will be rental discrimination and or bidding practices, along with other breaches. The outcome of this is that the House of Commons rejected this proposal, and they feel that civil penalties are the standard within the sector, and they want to keep that consistency as opposed to add another level of burden, as it were, and impose criminal penalties. So what next? Planning is key. So although we don't have royal assent, one of the things that you need to factor into the scheme of things is that if royal assent does happen before October or on October the 1st, you need to think about implementation. That's what we need to look at. It's very, very important that you have a really good understanding of the 10 elements, and there are 10 key elements of the Renters' Rights Bill, and that you are ready to implement them. Now, some of those elements will be introduced on the day that the law is implemented. Okay, and I said it could be 3 months after royal assent is given, or 6 months, but that is important to be aware of. So those changes that will happen on that very first day will just happen. Okay, so you need to understand what that will look like. Very few amendments have been accepted, those amendments that were proposed by the Lords. The majority have been rejected, so it will mean that time is of the essence. When royal assent is granted, you need to look at the window of opportunity to get things done. And like I said, it could be 3 months or it could be 6, but that's something that you need to think about very carefully. So you really need to start putting together a very robust, very clear action plan as to how you're going to manage the implementation of the Renters' Rights Act. Okay, so we will have further takeaways that will be what I call a very special consideration being given to the Renters' Rights Bill. And then once royal assent is granted, the Renters' Rights Act, and we will provide further information on how to navigate these legislative changes. Thank you for listening, and I hope that's been very beneficial.